Good afternoon. Good afternoon, everyone. How are we doing today?
Good afternoon. Fine, thank you.
Great, great. Okay. So on Monday, we were discussing the doctrine of foreseeable harm. We talked about the method that Commonwealth courts use to apply it in order to engage in a remoteness analysis, right? To determine whether the damage done to the plaintiff is too remote to impose liability. So today, we're going to take an alternative approach to a remoteness analysis. We're going to look at an American case that uses a different approach that has been followed by some American states. And we're going to ask how this approach changes the outcomes that we're used to. Why are we doing this, right? Why are we spending time on this? The purpose of this lesson is to give you some tools in order to think about law reform, right? In order to think about, is the status quo the best way to engage in this analysis, or are alternatives better? And so one of the things that I would encourage you to keep in mind is that there's a very strong possibility that you will be examined on some sort of law reform issue, some sort of policy issue, and you will be evaluated on the basis of the quality of the argument for reform or for the status quo that you offer. So this is going to be the majority of what we do, but before we get to that, there is one other piece of the Commonwealth doctrine that I want to dispose of, and that is the egg skull plaintiff rule, or sometimes it's called the eggshell plaintiff rule or the eggshell skull plaintiff rule, right? These are all the same thing. What this rule says is that a defendant cannot escape tort liability for damages that are caused by the plaintiff being uniquely vulnerable. Okay? Let me give you an example, because that phrase doesn't necessarily mean a lot sort of in the abstract. Classic example is that if you throw a rock and you're not really paying attention to where you throw it because you don't think anyone's around, but someone is around, and you hit them in the head with the rock. Now, a normal person, right? A normal person who is hit in the head by a rock that you have thrown might be bruised. There might be a little bit of bleeding if it happens to catch them on a sharp edge and cuts them, but it's not going to be an extremely dangerous incident. This person that you have hit in this hypothetical happens to have very brittle bones, and the rock that you throw smashes their skull and kills them. Okay? Under the egg skull plaintiff rule, you can see where it comes from now. The defendant, you, the person who threw the rock, cannot claim that their liability is limited to the damage that a normal person would have suffered. So the defendant takes their plaintiff as they find them. Okay? If your plaintiff is uniquely vulnerable, then the appropriate measure of damages is what a uniquely vulnerable person would have suffered. And it's essentially just a doctrine that prevents defendants from assessing the measure of damages as to some sort of, paragon of physicality who can be harmed by nothing, right? We're not measuring our damages against Achilles, we're measuring them against the actual person who was harmed. Okay? So before we move on to our American case, I'm curious as to how you would see this doctrine interacting with the superseding cause doctrine. So you'll recall that the superseding cause is where some sort of subsequent event exacerbates the damage to the plaintiff, and the defendant's liability is cut off by that superseding event. So they are only liable for the damage up to that superseding event. So how would we put these two doctrines together in a way that makes sense?
So, sir,
Yes, go ahead, Rudolph.
using your scenario of the rock thrown and struck someone, let us say that using the eggshell skull principle, let's say that that person is a Jehovah's Witness, and you know they're not allowed to take blood and so on. And as a result of that, this rock struck them, and let me say it's a situation where they really need blood to survive. If you apply this principle, and that person suffers extensively, if we use this taking the victim as you find them, it means one, because their religion prevents them from taking blood, any subsequent suffering they suffer, you're also responsible for. Whereas before, when we look at the superseding one, damages is only up to that point that the person caused that damage. So I see one like one is like a reverse of the other. Well, that's how I'm seeing it.
I think that's absolutely right, right? I think the key issue in determining which doctrine applies is the sequence of events. So if the vulnerability comes about before the negligent act, then what you have is an egg skull plaintiff, and the defendant is on the hook and takes the plaintiff as they find them. If the vulnerability arises after the negligent act, well, the defendant can't foresee that later in the future, the plaintiff's going to develop this vulnerability. And so it would not be just to hold the defendant responsible for the additional harm caused by this vulnerability. So I think, Rudolph, I think you're absolutely right that these doctrines are to some extent mirror images of each other. So I think that is absolutely right as the answer, and I quite like your example of the Jehovah's Witness because I think it very neatly falls into that boundary area. Because is the vulnerability the religious belief, in which case it would come prior to the negligent act, or is the vulnerability the refusal of the transfusion, in which case it would come after the negligent act.
Right.
And so how the court characterizes the vulnerability determines which doctrine you apply. And is there a principled way in which we can differentiate between these two? I can't think of one off the top of my head, which doesn't mean that there isn't one, just that I can't sort of think of it. But I really like that example, and I'm going to steal it. So I will be using that example the next time I teach this class. So I think this. Yes, go ahead, Pamela.
Although I'm trying to understand Rudolph, and I think I'm following him a little, but can you just go over that one more time? Sure.
Right. So the idea is, and I see the private message that was sent to me, and I'll come to that in a second. So the issue is, what's the sequence of events? Okay. If someone is already vulnerable at the time that the defendant is negligent, then we can impose that vulnerability on the defendant because they should have foreseen that, you know, someone who was vulnerable in this way could be harmed especially badly by their negligence. Okay, so that's the egg skull plaintiff principle. And the superseding cause doctrine says that it is not just to hold the defendant responsible for damage that was not a foreseeable consequence. And so the fact that you were going to develop this vulnerability in the future, not foreseeable. And so we don't think that it's appropriate to assign it to the defendant's liability. Okay?
Yes, thank you.
No, thank you for asking. So, private message, do you think that the principle should be reformed? Because what if the person, as Rudolph said, was playing a sport and got injured? They knew the risk but still proceeded, and thus they want the person who harmed them to be liable because the person died. Would you say the principle should still apply knowing that the victim knew the risk? Okay, so this is actually a different doctrine to the person who sent me this message. This is actually a defense to liability called the assumption of the risk. Okay, that we say that under certain circumstances, plaintiffs knew that there was a risk that they would be harmed by something, and they chose to undertake whatever they were doing despite that risk of harm. And so they have assumed that risk. Okay. What we're going to talk about defenses next week. And so beyond sort of this, what I've said just now, we're going to put a pin in this conversation until next week. Okay. All right. So, what other questions are there about the egg skull plaintiff rule before we move on?
Sir, I think your explanation to Pamela just now clarified that for me.
Go ahead, Sally. And what? Say that again.
I was saying that the explanation you gave just now when Pamela asked the question clarified all my concerns with that.
Okay, great. I have a question sort of coming in phases in the chat privately, so I'm waiting for it to come in. Okay, so the question is, I get that you have to take your victim as you find it, but it is the superseding cause thing that confuses me. So what I want you to think about when I sort of raise this is connections between the pieces of doctrine. Okay, these doctrines that we've been learning are not they don't sort of stand in isolation. Okay, this is forming a whole body of law, and the superseding cause doctrine can be thought of as a mirror image of the egg skull plaintiff rule. And the difference in which one you apply depends on the time sequence. Okay, so does that help? I don't know if it does. I feel like I've just repeated myself, but
I think so. Yeah.
okay. Well, look, I promise you.
I have a question. Okay, so
okay, go ahead.
The eggshell principle one, if they already have the problem, the defendant would be held liable regardless.
Right.
And so for the superseding one, if they develop like maybe hypothermia, whatever, any disease after, then the defendant would be off the hook.
If the disease exacerbates the damage caused by the defendant's negligence. So, so like the example is in a car wreck, you have some sort of lower back injury, okay, and that's caused by the force of impact sort of being transferred into your spine, and then later in life you develop scoliosis or arthritis in that same part of your body. The defendant is not responsible for the additional damage done to you by the disease. So does that help?
Yeah,
Okay.
it does. Thank you.
No, thank you for asking. Okay, so let's move on. The case for today is Palsgraf versus Long Island Railroad Company. This is a New York case from 1925. It is a classic in American tort law. Every case book uses it to teach this topic because the Court of Appeal splits. It's a 4-3 decision, 4 siding with Justice Cardozo in the majority, 3 siding with Justice Andrews in the dissent. And it has been extremely influential in the development of what the Americans call proximate cause, but what here we call remoteness analysis in the American states. About half the states follow Justice Cardozo's doctrine, about half follow Justice Andrews. And if you read Justice Andrews' dissent, right? If you read Justice Andrews' dissent, you would know that Justice Andrews uses a very similar analysis to what you were taught on Monday. Okay. One of the things that he does not do, one of the things that Justice Andrews does not do is he does not ask the third question that we learned about on Monday relating to the type of harm being done. There is some language in the opinion where he talks about the type of harm in a way that that I think points in that direction, but he doesn't ask the question explicitly. Okay? But let's start with the facts of the case. We have a gentleman who is left unnamed because he's not really relevant to the case. He's trying to board a train that is leaving the station. Okay. A train owned and operated by the Long Island Railroad Company. 2 of the railroad's employees are trying to get him on the train. So one is on the train, they've reached out, they've grabbed this gentleman and they're trying to pull him onto the train. Another gentleman is behind, another railroad employee is behind the gentleman, pushing him on. So the push-pull dislodges a package that the passenger is carrying. Nobody has any way of knowing what's in the package. There's no marking on it. It's not, there's nothing to indicate what it is. And it drops between the platform and the train. We're not told entirely how this happens, probably because the court wasn't able to figure it out. My guess is that the package probably slipped under the wheels of the train, and it consisted of fireworks. And it exploded. Unfortunately, what we are not told at any point is what happened to these poor 3 men who were right over the exploding package. Instead, what we are told is that the explosion, the force of the explosion, knocks some scales off the wall some distance down the platform. The scales fall off the wall and they strike Mrs. Palsgraf, injuring her. So these are the facts. So let me just check in, make sure. Do you guys, what questions do you have about the facts of the case?
I can see this happening when you particularly in a New York train station. I can see. I've used that several times, so I kind of understand these facts. I agree
Okay.
with you though that no emphasis on anything is said about the two workers or the passenger himself. That's interesting.
Right. And part of it is because they aren't parties to the case, right? And so what happened to them, not really important for the disposition of the case. Have a private question. Who was the person pulling him on the train? Was it a worker? Yes. Both the pulling individual, they're described as a guard, and then the pushing individual is described just as a railroad employee. Okay, it's not clear what their job is. So yes, both the pulling and the pushing people were employees of the railroad. Okay. One of the things that I think is really interesting about this case is that the dissent and the majority seem to be telling different stories about the facts of the case. So, for example, Justice Andrews' dissent makes it very clear that Mrs. Palsgraf was planning to board a Long Island Railroad Company train. She was one of their passengers waiting for a train. Cardozo's opinion sort of slides past that and maybe implies that she was there to board a different company's train. Doesn't say one way or the other. Do we think that the railroad would owe a greater duty of care to a passenger than to a bystander?
Particular, sir, but I think a passenger. I don't know why, but I think a passing. Well, I can't say I don't know why. Passenger, a bystander. A passenger is kind of your responsibility. Like it's an automatic duty of care, where a passerby.
So we're gonna talk a little bit more about this after we finish up negligence. But one of the things that you should know is that occupiers and operators of premises like railroad companies running a station do owe different duties of care to different classes of people, and generally the highest duty of care is owed to those that are there at your invitation to transact business with you. Okay. And people who are just sort of standing around and waiting on your premises may be owed a lesser duty of care. So you're absolutely correct, right? That the fact that Mrs. Palsgraf is a passenger would mean that there is a greater duty of care to her. And Danielle is absolutely right that there is also a general duty to bystanders, and we're working up to some of these things that you guys are bringing up in the chat. So you guys are really doing a great job of thinking ahead, but let me sort of build up to this. So Jaleesa asks, would it matter how close the passerby is? And I think that's exactly the next point that we want to raise, right? Is that if you look at the facts in Justice Andrews' dissent, he's clear that there's some distance, but he's a little vague as to how far from the explosion Mrs. Palsgraf really was. Justice Cardozo, for the majority, is very clear, right? He claims that she's standing all the way at the opposite end of the platform. And it seems like, Jaleesa, you would suggest that that matters. Do you think that that matters?
I think that the the distance, it might matter because if the passerby or the other person, the bystander or whoever is, like close to the railroad, then I think that they still have a duty to the person. But if the railroad is probably like up the gap and the person is very, very far and they
Mhm.
still happen to, be involved in the accident or whatever, I think that the railroad may not have that much, duty to care for her depending on her distance.
So Joy asks, is it not one continuous platform? And the answer to that is we don't know. The facts do not disclose this with any sort of clarity. Given just sort of what we generally know about the state of Long Island in the 1920s, I think it's very likely that it is sort of one continuous platform, that the station is not large enough to accommodate multiple platforms. But I could be wrong about that. So I have a private question. We can agree that an explosion creates a sort of knockdown effect due to the shock wave. So we're going to get to that in a minute. And then another private message, would this have to deal with proximity and the neighbor principle? Yes, yes, it does.
But not physical proximity.
I'm sorry, go ahead, Joy.
I was saying, but does that include physical proximity? Because I think the proximity really has to do with the relationship in terms of, being a passenger and so on.
So just to wrap up the location discussion, right? We know that Justice Cardozo has represented to us that that Mrs. Palsgraf was, all the way down at the opposite end of the platform. Would our analysis of this issue change if I told you that when Mrs. Palsgraf applied for rehearing, asked the court to reconsider the case, that she argued that, in fact, she was much closer to the explosion than Justice Cardozo had said, and that the court had misread the record? Does that change our analysis? Go ahead, Rudolph.
Yes, it should. But
Okay.
there's something I'll say that Justice Cardozo says, and I think it's interesting in here. It says the plaintiff, as she stood upon the platform of the station, might claim to be protected against intentional invasion of her bodily security. Such invasion is not charged. She might claim to be protected against unintentional invasion by conduct involving in the thought of a reasonable man and unreasonable hazard that such invasion would ensure. So when I look at this, even before you said that when she filed for retrial, I'm asking the question, if a duty is owed to her, and normally you say that this is negligible, a duty of care, and somebody just said rightly, this whole concept of the principle of neighborhood principle, etc. If we take this into consideration, I will say that some form of duty is owed to her to protect not only her, but any person within the confines of the train station, especially in proximity of a moving train.
Okay, so I would say that what you have done with this is you have actually combined Justice Andrews and Justice Cardozo's analysis. I think what you have done is you have stated Justice Cardozo's analysis more broadly than he does. So let me explain what I mean by that. Justice just a very quick digression. There's a question in the chat, a private question. What kind of injury did she sustain? Was it physical or psychiatric? The answer is the record does not disclose it, but we can assume that it was physical. Okay, and either way, it would still be damage to the body. So the 3 types of damage inquiry, it would still be damage to the person. Okay, so to return to my point from what Rudolph said, right? Justice Cardozo's argument is that this foreseeable harm principle, right? The approach that we take in the Caribbean, that what it does is it creates what he calls negligence in the air. And so you have sort of these torts floating around waiting for a victim. And he says, look, the duty of care has to be owed to someone. Okay, you can't have a tort without a victim. And so he says that the foreseeability analysis in this case, and in every case that follows his argument, is that the duty of care is owed to those who are foreseeably in the way of the harm committed. And so this is referred to as a foreseeable plaintiff, a foreseeable plaintiff. Okay? A private message, for there to be a duty of care, there must be a risk to injury. If she claimed that as the package fell, it was nearer to her, then she would be seen as being a neighbor. And also explosions have no sense of direction. Therefore, anyone who were not foreseeable could be harmed as a natural consequence of the event.
What about remoteness in that?
I'm sorry, say that again, Rudolph.
I said, look at that no entire remoteness to that. Could the guy carrying the package, even though it was so well secured, could he have remotely thought that for some reason or the other, if this fell out of my hand, even if I was walking on the track, was it possible that it could hurt somebody?
Exactly, right? This is taking Cardozo's analysis, reaching Cardozo's conclusion using the foreseeable harm analysis, right? We are asking, right, is this a foreseeable consequence? Do we think that pulling someone onto a train leads to an explosion? That seems unlikely, right? But Justice Andrews says that once the negligent act is committed, that it exists, right? The duty of care has been breached, but he distinguishes between negligence and tort. So Justice Andrews says, look, you can be negligent, okay, and that has happened and you have breached the duty of care, but if no one is harmed, then no tort has been committed. Okay? Think all the way back to week 1 of the course. We talked about damnum sine injurio, right? Wrong without injury. And tort does not grant liability for those situations. So if you are negligent and lucky, you are still negligent, and someday your luck is gonna run out, right? So, but when someone is harmed, then we impose liability, right? That's exactly right. So go ahead, Danielle. Go ahead.
Sorry,
Danielle.
that wasn't accurate. But
okay.
I do have a question though.
Okay.
So, in Hughes v. Lord Advocate, they held that employers are liable for their consequences, and it doesn't matter if you couldn't foresee the specific sequence of events, as long as it was reasonably foreseeable that that general type of damage could have occurred. So I think if it was supposed to be based on that ruling, it wouldn't be foreseeable that that specific type of damage could occur because it wasn't on the fault of the railway company. I don't really
Yep.
see how they could have been negligent in causing that harm.
Yep. Well, the negligence is right. We're past the question of whether a negligent act occurred when we're talking about remoteness, right? So negligence has either been admitted or been found, right? The act of pulling the passenger onto the train was negligent. The question is, was the harm to Mrs. Palsgraf foreseeable? And Justice Andrews takes the position that once you have the negligence, you know, the harm that comes as a consequence is, you know, is going to land, right? And there will be liability. Justice Cardozo says that if there's no reason to think that this plaintiff would have been harmed by your negligence, then there's no claim. So Justice Cardozo, right? So remember we said at the very beginning of our discussion of this case, there's 3 people involved in this incident who we don't know what happened to them. Okay, and I think that we can agree that Justice Cardozo's analysis would find liability for the passenger, or find liability against the railroad for the passenger that was being pulled onto the train, right? Because he would be a foreseeable plaintiff. Does that make sense? Danielle, does that help you understand kind of where we're going with this?
Yes, that was my initial concern because I didn't see why it was the railway at fault because they're not the ones carrying the explosives. So I would think the passenger is.
So there's a very practical answer to this, and that's that the railroad is the one with the money, or the insurance, and so we're looking for, the plaintiff's lawyer is looking for a path to get the railroad on the hook. Okay. And here is sort of the hidden fact that maybe can explain why Justice Cardozo is engaged in these mental gymnastics in order to find that and creates this whole new standard for remoteness in order to find that the railroad is not liable. Before he took the bench, Benjamin Cardozo represented railroads. So you remember how last time I was talking about how we want a judiciary with diverse experiences, right? We don't want everyone on the bench to have come out of Harrison's and Huey and Hugh Wooding and then go into a White Silk Chambers and then go on the bench, right? We want lots of people who come to the bench from lots of different perspectives. So let's try and put this together, right? So let's start by applying the 3 questions that we talked about on Monday to the Palsgraf facts. So taking these in turn, right? Was the instrument of harm a reasonably foreseeable source of danger?
You're referring to the fireworks?
I mean, that's an interesting question. Is the instrument of harm the fireworks, or is it the train, or is it like the act of pulling someone onto the train?
Yeah, I like this. What not said though?
So it seems to me that it doesn't matter how you describe the instrument of harm. All of the options are a reasonably foreseeable source of danger. Okay.
Okay.
But how you characterize the instrument of harm matters when we move on to the next question. Was the way in which the instrument of harm caused the damage reasonably foreseeable? Okay. So some folks are saying no. Okay. Is there anyone who wants to argue that it is
I
reasonably
can say yes.
foreseeable?
I can say yes.
Okay, why
But
would you say
Let me hear
yes?
somebody else first. Let me hear somebody else first.
I would
Okay.
say yes in the instance of the fireworks, because the way how I'm assessing it is the instrument of danger and the harm that it caused. The
Mhm.
pulling and pushing of the passenger wasn't the harm that we're assessing, which was to the lady, right?
Right.
So that right at the moment, I think, is the least significant factor. While it did play a part in causing the fireworks to fall under the train, that within itself isn't, if we're going to look at it in the sense of remoteness, I don't think that has much relation to do with the lady who was injured. Secondly, when you're assessing fireworks, they within themselves are inherently a dangerous thing. They come with warning labels. You know, you have to take reasonable care when you're dealing with these things. They're not toys.
Maybe not in 1925, but I take.
Well, yeah, I guess they were wilding back in the roaring 20s, but
right.
My point remains the same. You know, they are very inherently dangerous things.
Mhm.
So whatever harm that occurs from carrying fireworks is any harm that is foreseeable, because if we're going back on the principle of Hughes v. Lord Advocate, it doesn't matter the specific sequence of events that caused the damage, as long as the general type of damage was foreseeable.
So this is exactly the analysis that Justice Andrews is taking. Go ahead, Ward. Go ahead. I'm sorry.
In relation,
you faded out on us. Go ahead.
Pardon?
You faded out on us. Try again.
Oh, I said in relation to what she said about the fatalities as it relates to the fireworks, I would say that in 1920?
1925.
1925, right? There would not have been, there wouldn't have been a record of who would have died from fireworks for them to see how fatal it was. So that would be my argument against it, that there might not be sufficient evidence for them to know how dangerous it is, just how dangerous it is.
I mean,
I don't agree.
We knew that explosions were dangerous in 1925, right? That's after World War. That's after the First World War.
Right, yeah, but the size of explosions matter, doesn't it?
So, absolutely right. I think that's an argument you can make. I'm not sure how convincing it is, but I would not describe it as being made in bad faith or as being frivolous. And yes, Joy, I think you're
Let's
correct.
Let's say a third question though.
Yeah, I think that Hughes is decades later. I think Hughes is like mid 20th century. So one of the things that I want to reiterate for us, right, something that came up earlier that I want to refocus on this particular inquiry is that, explosions have shock waves, right? And the strength of the shock wave sort of varies depending on the size and nature of the explosives, but they are there. Okay, and so like knocking something off a wall from an explosion, maybe that's a reasonably foreseeable way in which explosives can harm someone. But you can also, like, I think you have room to argue that no, this was a weird case. This is not one that would be foreseeable, and so we shouldn't impose liability. Like, I see both sides of that argument. Okay, and then the last question in the analysis is: was the type of damage reasonably foreseeable? And you guys will recall from Monday, we talked about how judges can have some discretion in how they approach this question that gives them some room to point in a couple of different directions, right? They can approach the categorization of damage very broadly. They can say that, well, it's harm to the person, and the harm is still, the harm of an explosion is going to be harm to the person, and so that's reasonably foreseeable. Or they can say, right, if they want to draw it narrowly, they can say that the reasonably foreseeable damage is, damage to the person who sort of is caught in the explosion. It's not damage from things being knocked down by the shock wave. Okay, so does that make sense that, to some extent, drawing this third question narrowly, like you can argue that it gives the judge a second bite at the second question. Okay, so I think that, most judges are going to tend toward applying it more broadly. Private question, did the luggage carrying the fireworks have warnings on it? Justice Andrews in his dissent is clear that there is no way for the railroad's employees to know that this package contained fireworks. So that answers your question. Danielle says, I disagree with the narrow perception. I think I do too, but as the lecturer, it's my responsibility to sort of give you the options as to how things might be interpreted. And then, you, when you're out in practice, will make arguments that make sense for your client.
My
Okay.
concern is this for your third question.
Mhm.
If I'm going to put the harm in relation to what caused the harm, I would argue that it is foreseeable that any form of explosion will cause serious harm. Because, for example, if you were to say, well, if you had a knife, you would not foresee the harm caused by a knife in comparison to harm caused by, let's say, the same fireworks. So the harm then has to be greater with the fireworks than that with, let's say, a little knife. So if I'm going to say, well, was the extent of that harm, how foreseeable was it? I'm going to say, well, and I do agree with what you said just now, even though one may remotely say that the aftershock of the explosion is one that you could give consideration to. One can then counteract that by saying, but most explosions, like for example, an atomic bomb is not the actual explosion that does the damage, it is the aftershock. It is when a bomb falls, it is that aftershock that does the consuming. So if I were to argue that, I would say yes, that as long as there is an explosive device, that one should be able to foresee that it is going to cause considerable harm.
Danielle, you said you wanted to offer something.
Similar to what Rudolph was saying, because fireworks are, once again, an inherently dangerous thing. So to say it wasn't foreseeable that the sequence could have occurred, if we're going to look at it at just limiting this principle to the facts of the case, then when you're assessing that, you can identify the fact that the effects of a firework would also have to be taken into consideration. So when they explode and whatever ultrasonic waves bounce off the wall and cause any type of injury, it's fairly foreseeable that the effects of a fireworks are also inherently dangerous and not the direct explosion itself. Similar to an atomic bomb is really just firearms at a greater scale. The initial blast we know is very deadly, but so is the radiation and whatever comes after it. So, and it's the same thing when even if you could say there was less safety regulations for fireworks in the 1920s, there would have still have to be a basis of a warning, because at the end of the day, it's still like a firearm, and firearms did have warnings back then. Like the Winchester gun company, for example, they always put out disclaimers, and that was a gun company established in the 1800s, 1700s, I think.
Yeah.
So
I'm sorry,
fireworks
go ahead.
similarly, I was just saying, so fireworks similarly, you would have to anticipate any damage that they could bring about, whether direct or indirect. It was still foreseeable.
Mhm.
Yeah.
Yeah, I think everything that you guys are saying is correct. And I think that, one of the things that I really wanted to illustrate here was the difference that this very slight change in our analysis can make, right? If we are asking about whether the harm is foreseeable, then we're analyzing what was done to the plaintiff. But if we ask whether the plaintiff is foreseeable, then we're asking about, like, who is the defendant looking out for? And one of the things that I think is useful to ask is, what kind of society are we trying to build? Are we trying to build one, right? Because all of this is built around the notion of trying to build a better society, right? So are we trying to build a society where people generally feel responsible for one another? Or are we trying to build a society where we can draw sharp boundaries between who these people, who's in and who's out? Okay, so Shasia asks, how was Mrs. Paulsgraf able to bring a case against the railroad? Because with foreseeability, the only harm they could foresee from their actions would be to the passenger they were pushing. It seems to just be based on the fact that the explosion only happened originally because of their original actions of pushing and pulling him. And I think that's absolutely right. And I think that's Justice Cardozo's analysis, that any duty that was owed to the passenger who was getting pulled onto the train. Okay. The duty does not sort of exist in the air to anybody and everybody. Justice Andrews' point, and this is the last thing that I'll say, and then we'll call it a day. Justice Andrews' point is that the duty of care is owed regardless of whether there is someone who can be harmed or not. But the tort, right, which imposes liability, is not complete until someone is harmed. But whomever is harmed is an appropriate plaintiff. So again, I don't have a strong stake in this as to which side I want you to come down on. I want to make sure that you understand the logic of both sides and have an informed reason for preferring one or the other. And as a descriptive matter, I want to make sure that you understand that Justice Cardozo's argument carries zero weight in any Commonwealth jurisdiction. Okay, this is an alternative that is not the law anywhere except some places in the United States. Okay, so we are out of time, but this has been a really great discussion. I really appreciate you guys. And I will see some of you over the course of the rest of the week, and the rest of you I will see on Monday. Okay, so next week we'll be talking about defenses, and we will see you then. So take care.
You too, sir.
And bye.
Bye.
So.